Good day, everyone. My name is Asharim Karim, third year criminology student at the University of Mindanao, Davao City. Welcome to my channel. As provided for under Section 4 of the new Anti-Terrorism Act, a person is guilty of committing terrorism when the purpose of such act by its nature and context is to intimidate the general public or segment thereof, create an atmosphere or spread a message of fear, provoke or influence by intimidation the government or any international organization, seriously destabilize, destroy the fundamental political, economical, or social structures, create a public emergency, or seriously undermine public safety. Thus, when the purpose of the act is any of the above enumeration, such act is punishable under the new Anti-Terrorism Act instead of the revised penal code or the special penal law. It was provided under the Rule 7.2 of the IRR of the RA 11479 that the requirements in order for an individual or group to be tagged as terrorist when there is a group of association shall be prescribed or declared as terrorist and outlawed by the authorizing division of the Court of Appeals upon satisfaction of the following requirements. Recommendation from the National Intelligence Coordinating Committee or NICA that said group of person, organization, or association be proscribed or declared as terrorist and outlawed. Authority from the ATC to cause the filing of in application for proscription or declaration of said group of person, organization, or association as terrorist and outlawed. Verified application of the DOJ to prescribe or declare a group of person, organization, or association as terrorist and outlawed with an urgent prayer for the issuance of preliminary order of proscription. And an order of the prescription is an order going individual or group of terrorists. Due notice and opportunity to be had given to the group of person, organization, or association to be declared as terrorist and outlawed. It is mandatory for the Anti-Terrorism Council to determine order for it to be able to establish probable cause to tag an individual or a group as terrorist. However, there is no exact definition of probable cause provided for under Rule 7 of the IRR on the proscription of the terrorist. The definition of the IRR on the designation of the terrorist and designated is a distinct ATC power under Section 25 of the Act, separate from the court's power of proscription. For purpose of designation, Rule 6.3 of the IRR provide that probable cause shall refer to reasonable ground of suspension supported by circumstances warranting a cautious person to believe that the proposed designee meets the requirements for designation. In the new law, it is not necessary that the individual or group be tagged first as terrorist before they can be charged, because they can be designated as terrorist pursuant to paragraph 3 of Section 25 of RA 11479 without the need for court process of proscription. The ATC have issued Resolution 12 and 13 designating the terrorist group pursuant to Section 25 and 45 of the Anti-Terrorism Law. Number 1, Communist Party of the Philippines and the New People Army, CPP-NPA, and Islamic State East Asia, Multi Group, Dawla Islamiyah, and other associated groups. Preparatory acts, as a general rule, are not punishable unless there is a law that defines them as crime and provide for the corresponding penalty. In line with this, preparatory acts committing a terrorist act that are punished in the new Anti-Terrorism Act can be found under Section 6 to 14 of the law, which punishes planning, conspiracy, proposal, and inciting to commit terrorism, among others. More specifically, Section 6 provides that it shall be unlawful for any person to participate in the planning, training, preparation, and facilitation in the commission of terrorism, possessing of objects connected with the commission of terrorism. Any person found guilty of the provision of this act shall suffer the penalty of life imprisonment without the benefit of parole and the benefit of Republic Act number 10592. However, one of the contentions of petitioners during the oral argument in Supreme Court was whether it is necessary for the legislator to pass a law penalizing a preparatory act. The issue here is that punishable because it may not be clear or intent what the resulting felony or crime. Under the law, a terrorism suspect could be detained for 14 days without charge, a period that can be extended to 24 days. This is only a problem in the new law that was passed because this violates a constitutional provision that a person must be charged within 3 days of detention. This issue can only be resolved through attacking provisions in Supreme Court. This is very important since it is crimes against national security, and by doing this, it prevents the national government to undeniably diminishes the due process protections.